Mr. Chair, we're live.
Thank you. Good morning, everyone. I will now call the hearing to order. I would like to begin by acknowledging that we are in Treaty 1 territory and the traditional homeland of the Métis Nation. This morning, I will be chairing the hearing. My name is Robert Hutchings. On the panel with me today is Ms. Anderson and Ms. Rempel. The assessor representing the Assessment and Taxation Department this morning is Mr. Wong. We will be hearing applications for revision of the assessment role in accordance with the Municipal Assessment Act. The matters for which revision is requested have been described in each application, and we will limit discussion to those matters. The statements that are made at this hearing are sworn testimony, and anyone speaking to the matters must be sworn in. Be advised that comparisons of assessments of properties are not considered evidence of market value by this Board of Revision. The Board of Revision is appointed annually by council and is independent of it and the city administration. It makes its decisions on the basis of the evidence provided at this hearing and issues a written order that will be mailed to all parties as soon as possible. Please note that the board's decisions with respect to an application may be appealed further to the Manitoba Municipal Board if the matter pertains to assessed value or classification or to, or to Court of Queen's Bench if the matter pertains to the application of exemptions from taxation. Should you wish to appeal, information on how to do so will be included with this board's order. With respect to the hearing process, I will confirm the points of appeal with your property to be addressed with each application following their swearing in. We will then have the assessor's testimony followed by cross-examination by the appellant and then the panel members, and then the applicant's testimony followed by cross-examination by the assessor first and then the panel members again. Each side will have an opportunity to summarize if they wish. Once all of the evidence about an application has been brought forward, the applicant may leave. The process will repeat for each item on the docket today. The session will close after all the applications have been heard and the board will deliberate in private and make its decisions. You will receive the board's decisions by registered mail as soon as possible. As information, all public hearings are live streamed, recorded, and will be part of the public record. Ms. Kara, could you please swear in the assessor and the applicant? I guess the applicant is representing both appeals today.
Correct, no problem.
Thank you.
Mr. Assessor, for the record, please state your name. You'll have to unmute yourself.
Wong.
Thank you. And do you affirm the evidence you'll present today is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. And Mr. Applicant, for the record, please state your name.
Jared Story.
And do you affirm the evidence you'll present today is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Thank you, Kara. Okay, first property on the docket today is 415 Logan Avenue. We're dealing with a 2022 realty appeal. And I see that there is a preliminary issue to deal with here. The assessor is requesting a non-compliance. Mr. Wong, if you'd like to proceed, and please enter the property for the record, and then detail what the preliminary issue is, please.
Okay. The subject property is 415 Logan. The roll number is 130-817-85000. And we're requesting that the burden of proof be placed on the applicant for non-cooperation as per Section 53 of the Municipal Assessment Act, and order that any reduction in assessment to be follow Section 54 3.2 of the Municipal Assessment Act. But yeah, we're seeking non-cooperation because the applicant, we requested information from the property owner and they did not supply it. On page 11 of my brief is the parcel tracking that shows our proof of delivery. On page 12 is the front page of the letter that was sent requesting the information. And in the middle of that page, it's a request. I mean, we sent out a request in April, and there was no response. So we sent out a certified letter in June, and there was still no response. And so we are seeking non-cooperation because the applicant did not respond to the assessment department's request for information.
Okay. Anything else right now, Mr. Wong?
No.
Okay, thank you. Perhaps instead of using the section of the Act, could you kind of summarize what those two sections state for the record?
53, section 53, subsection 3, where the applicant fails or refuses to give an assessor a reasonable opportunity to inspect the property, or more applicable in this instance is to comply with the request for information and documentation under section 16. Board shall, at the hearing of the application, place the burden of proof on the applicant on all matters at issue. So that's what we're seeking here, is because the property owner did not comply with our request for information.
Okay, thank you, Mr. Wong. Mr. Story, any response to the request for non-cooperation?
Yes, thank you, Mr. Chair. I do have some questions of the assessor, if
Yes.
I may. Okay, Mr. Wong, just so we're clear, the mailer was sent to a PO box on June 7th. Is that correct?
Yes.
Okay, and you'd mentioned proof of delivery, but we don't in fact have proof of delivery because we don't have a signature, do we?
I'm not sure if somebody signed it, but we did send it.
Okay, and it was returned to sender based on your evidence, correct?
I'm not sure.
Okay, so on page 11 of your CPC tracking details, if you look under description, that heading that says description, that's the 1, 2, 3, 4, on the 5th box down, it says the item was successfully returned to the sender, just so we're clear. And actually on the 2nd box down, it says that it was returned to sender. So judging by your information, it appears that it was sent on the 7th, it was returned on the 8th, and then it was returned to the city on the 11th. So does that not, in your mind, does that not constitute to you that the request was not actually made, it was not received by the owner? It was not duly received, so can't be, the owner can't respond to a request that was not, that they did not receive?
Yeah. I'm not really too sure what we have to do in terms of, like, you know, getting a letter out to somebody. I mean, like, I feel that we've gone, you know, beyond what we are required to do. I mean, we requested the information twice, and we didn't receive a response. And if the owner refuses it, or for some other reason, I'm not really too sure, then that it's I'm not sure if you can use that as a reason for, you know, not complying.
Okay, can you agree with me though that it would be impossible for an owner to reply to a request that wasn't received by them? If they're unaware of the request, then they would not be, they're not able to comply to a request that was not duly received. Is that fair to say?
If they don't have something, then they wouldn't be able to respond to it. With regards
to those are my questions. Thank you.
Okay, thank you. Tracy, any questions of either party?
I have no questions at this time.
Thank you. Gisela, any questions?
I have no questions, thank you.
Okay, who will I address first here? So I'm looking on page 11 with that first attempt at delivery where it was returned to the city assessor, and it had been addressed to that post office box on Main Street. The second letter sent out as a follow-up, Mr. Story, I guess I'll reference this to you. It was addressed to, no, it's still to the post office box 2444 Station M, and that was in regards to property address 415 Logan Avenue. I assume that the address of delivery registered to this subject property is that post office box. Would you know, Mr. Story?
Yes, so I did look that up, this post office box is the main post office downtown. So that's the Graham Avenue post office. The tax statements and everything was going to that PO box at the time, but in subsequent years, where there were responses that were duly made and responded to, were at the actual Logan address. So that's what we know. But that's in terms of this matter at hand, Mr. Chair. Our point is that this is a fairly open and shut scenario where the request wasn't made, so could not be properly responded to. And I do have a submission that I would like to speak to once you've done your questions, if I may.
Okay, so did the property owner notify the city that it should be coming directly to 415 Logan Avenue, or are you saying, that the tax bills actually go to the same post office box number?
The tax bills currently go to 415 Logan, but again, this is a new client for us, so I don't know the history of where things were sent. All I know is that, judging by the assessor's evidence here, it would appear that this was returned to sender for whatever reason and was not received by the owner. That's the point of for the purpose of this exercise.
Okay, Mr. Wong. So you detailed that it was returned to sender, the original request for information, and then there was a follow-up sent out by the city assessor requesting that information because the first one was ignored. So there was a second attempt by the city assessor to get the income and expense statements. Is that correct?
We made two attempts, one through regular mail and one as a certified mail, and neither request was responded to.
So the process would be the city assessor sends out that second request for information, and then if it was that returned to the city? Do you know?
The first one, I'm not sure if it was returned to the city or not. We don't track that. I mean, so I can't say. I can't say.
Okay, no, well, I'm referring to the second letter, the second attempt. Did that one return to the city, or so you don't keep track of that either? I guess.
It appears that it was successfully returned to the sender on the fifth line. Have the tracking details?
No, that's not my question. My question is regards to the second letter, second attempt to get information.
Yeah.
The actual letter sent out by the city assessor. Yeah. Any tracking on what happened to that request? A registered letter, is that right?
Yeah. The registered letter was sent out, and I guess it was eventually returned to sender, and I'm not really too sure why.
So there was, to summarize, between two attempts, both attempts for information were returned to the city assessor or the city assessment department. That's right. So
the second one for sure, and we are sending it to the mailing address that we have on record for this property owner.
Yeah. So I guess my question is, Mr. Story states that the tax bill is the delivery address at 415 Logan Avenue, and yet the assessment notices are going to this post office box. Would they not match, or can you explain why they would be different?
Well, I mean, it's possible they may have changed the mailing address in between June 2018 and now. I mean, Mr. Story could give us the more information on if they indeed changed it, So I mean, it's that is possible. So, but we typically send it to the mailing address that we have on file. I mean, if you would like, I can check for the tax mailing address in June of 2018 and see what it was at that point in time. I can do that.
Well, I guess. I
mean, Mr. Story is saying that, you know, the tax bill's going there now. Well, what's going there now is not. I feel that, I mean, that's what it's doing now. A lot of things they could have changed mailing address between June 2018 and now. So, I mean, just because it's going there now doesn't mean that it was going there in June of 2018. So.
Yeah. And so on the first attempt, when it goes to the post office box, you get deposited in a box at the main post office, and then it's up to the owner of that box to pick up that mail, or does the post office sit on that mail for a little while and then empty that postal box? Like, how did it get returned if it went to a post?
Yeah, you know what? I'm not sure. It just says that it was returned to us. I'm not sure who returned it to us.
Yeah. So it's obviously sent to an individual postal PO box number.
Yeah.
Is that right, Mr. Story?
That is correct. Yeah, it was sent to a PO box. That's correct.
Okay, so the only person that would have access to returning it would be the owner of that postal box,
or Canada Post.
Well,
one or the other, but we don't know.
But how could they get into that individual postal box if it's owned by an individual? This agent?
Well, they do leave oversized mail in PO boxes, so they do have access to them. Again, I'm not sure. All I know is that it was not signed for. It was not signed as received by the owner. So I don't know who returned it. I see that it was returned to sender the next day. It was received on the 7th and then marked as returned to sender on the 7th. Now, the reason as to why, I'm not sure.
Yeah. Okay. So when this 415 Logan Avenue rents a postal box for their mail to arrive, there's nobody there. The post person will go there, open with the key, master key, deposit it, and then lock the door. So there's nobody there to sign for it. Is that fair?
Yeah, and typically there would be a slip left with the clerk, or a slip would be sent to the owner. So if you receive a parcel that's waiting at the post office, you get a slip. You take the slip to the clerk, you sign for it, and then your parcel or package is released. That's I don't know a ton about how the registered certified mail works in that regards, but I do know that in order to collect the mail, that a signature is recorded. And when we do see that the requests are made properly and they are they're signed for, and typically there's a signatory on file. There'll be a digital signature on that CPC tracking sheet, and we don't see that here.
But that's a normal circumstance where there's let's say somebody at a front counter signing for it, right? In this case, we have a dead drop spot in the form of a postal box that nobody's going to sign for.
Well, a certified letter or a registered letter does require signature. And that's why the city sends out the second request requiring signature. So it does require a signature.
Okay, so how would that be done at a postal box? You think that an agent, the clerk at the central post office does that?
I believe that you sign you have to sign for it. So you have to sign with I believe that you have a slip left in the box. Mm-hmm. You take that slip to the main counter and you sign. I've done this before where you sign a little digital box,
But
and then that satisfies because the owner is paid extra to have the certified or registered letter sent and signed for upon receipt. So the issue here is that there's no signature. That's the crux of the whole issue, is that we can't say that it was received because there's no signature on file.
So is this postal box still active for this address, for this owner?
As of 2020, everything is being sent to 415 Logan. So I'm not sure. Yeah.
You know, as of 2018, whether it was active?
Well, 2018 items were being sent there. I don't know about the history of any mail changes or anything like that. It appears that the address was changed, but the salient point here is that it was not signed for. That's the
Okay. So this all depends on whether somebody from 415 Logan Avenue went to that post office and picked up the mail. Would that be fair? If nobody attended there, then it's not the city's fault that it wasn't received. He's meeting the requirement of delivery, address delivery. But I think maybe we're in a situation where you don't know the answer to that question.
Yeah, I'm not sure. To be honest with you. Yeah.
Okay. Mr. Wong, can you confirm that that postal box was active? Like, is that a long process here, or?
I can't confirm whether that postal box is active.
Okay, oh, that's fair.
Yeah, but yeah, I mean looking on page 2 of my information. It doesn't appear that they've responded for 2015 and 2016, but like we've sent it, we've requested the information, and the property owner did not respond. With regards to why they didn't respond, I mean, I can't say, but the city has fulfilled its obligation to request the to send out the information, and we send it out to the address that we have on file.
So, Mr. Wong, in your opinion, whose responsibility is it to keep you updated on delivery address for a property?
We send it to where the property owner tells us to send it to. And so, yeah, it would be the responsibility of the property owner.
And Mr. Story, you've only been an agent for this property this year. Would that be fair, or?
This is a new client for us in this cycle. Yes, that's correct.
If you were managing this account, would you have notified the owner that they have to keep these addresses up to date?
That would typically not. Would be an administrative function that would be outside of, like, I mean, sorry, I'm not sure that I understand the question. Would I tell the owner to update their address?
Yes, with the city. Maybe I'll put it this way. Do you confirm that all the information that they provided to the city to receive income and expense questionnaires is accurate when you take on a client?
I guess that depends. That would be, I mean, in the typical course of the process of onboarding a new client, we wouldn't do a history of their mailing addresses. Not typically, no.
No, but when you take them on as a client, would you confirm that all the contact information is correct?
We would confirm their contact information for our records to be certain, yes.
Yeah, okay. But you weren't the agent acting for them at this time, so, okay, I'm just wondering, okay. All right. Do we have any other questions from any panel members? And Mr. Story, you said you were going to present something?
I do, yes. So I've submitted our brief on non-compliance and the request for the penalties as rebuttal.
If I
evolve
could just
into-
interrupt for a moment, Jarrett, I've just put that file, it's a 129-page document in the drive for you here, Ms. Rempel, and for the panel members who are remote connecting, it should be in the share drive link now. The document would be titled Rebuttal Applicant.
Okay. Mr. Story, before you begin, can you give us a moment to...
Yeah, absolutely.
And I've also emailed that to the assessor. Mr. Wong, can you confirm you received that email?
Okay.
Yeah.
It appears that everybody does have the document, Mr. Chair, when you're ready to direct the applicant.
I still do not have it, Kara.
Under applicant brief? It's going to be in the actual. Okay, thank you. And then when you want to go back to it. Okay.
It should be right in the folder via SharePoint. I'm just being advised that maybe if you refresh the window that it might appear. And if we are having some issues with this, maybe we could just call a short recess to make sure everybody has it.
Okay, Tracy, are you... I'm just scrolling down now, so bear with me.
It's a separate PDF from the agenda document.
Right.
So if you go back into the folder where you pulled the agenda from in the first place, there should be an additional document in there now. 21-269 and 21-296 rebuttal applicant.
Okay. Tracy, did you find it?
Yes, I have it. It's a 129-page document, that one.
That's correct.
Okay, perfect. I'll just quickly read through all of that.
I will make reference to it throughout, and I'll give you the relevant page numbers, but I'll try and summarize at the front.
Okay, I got it. Okay, here we go. Okay. Okay. When you're ready, Mr. Story.
Wonderful, thank you. Okay, so we have submitted a brief in response to the assessor's request for the imposition of the non-compliance penalty. As I said, I will try and summarize this as briefly as I can for you. Effectively, we maintain that this is a severe penalty and it would only have application in a very limited number of circumstances. Typically, where a request was made, was duly received, and was ignored, or situations where no information was provided. In this situation, the owner clearly did not receive the forms, as is evidenced by the assessor's evidence. They were returned to sender. There's no signature. So the taxpayer cannot be punished for not complying with a request that was not received. Again, this is evidenced by the tracking history, and when we see that the form was returned to sender the following day, right after receipt. So in terms of the submission, the municipal board has made it clear that the penalty would typically only have application in circumstances where the request was properly made, and again, where no attempt to reply was made. So in Litcherson, which is one of the leading cases on non-compliance, this is page 40 of my non-compliance brief, we do see that the assessor is not bound to pursue the penalty in this situation. There is some level of administrative discretion, and it states that if there's a lack of certainty whether the request was sent to the right party or to the correct address, or that it was duly received by the owner, then the assessor may decide not to raise the possible failure to comply. Page 44 of my brief goes on to say that the assessor bears the burden of establishing that the request has been brought to the attention of the owner. based on this submission of the assessor in this scenario, we see that the request was not brought to the attention of the owner. And page 40, and this is perhaps the most salient section, the concern of the assessor is not to punish the owner who fails to respond, but rather not to be blindsided in a subsequent appeal to the Board of Revision or the municipal board with information which was initially withheld or inadequately provided. So in our scenario, there's no information. This is a cap rate argument. We are not. There was no information that would have prejudiced the making of this assessment. So we do suggest that based on Literason and based on the some of the other decisions that we've seen, our owner did not receive the request. The department has not proven that the request was brought to the attention. In fact, quite the opposite. We see that this was not signed for and was returned to sender. So we do respectfully submit that the penalty or the punishment in this case is not appropriate, and we respectfully request that the board denies the assessor's request for the imposition of the penalty. Thank you.
Thank you, Mr. Story. Mr. Wong, any comments?
Just that the owner has responded to their request for taxes, and in previous years, in 2011 and 13 and 14, they did respond to the request for information, but for the 2012 year, they did not respond. For 2015 year, they did not respond. And for 2016 year, 16 and 17 year, they did not respond. And so, I mean, we're talking about semantics. We're talking about, say, potential technicalities. And the point is, the assessment department has sent out the information, and sometimes it is received, and sometimes it isn't, and or sometimes it is responded to. But it would be extremely onerous on the city to hand deliver for proof of to prove that it was received. And so and from the city standpoint, once we send out a letter, it is deemed to be delivered, and after a certain period of time, which is like 2 or 3 days or something.
Okay. Sorry, is there a question?
Mr. Story, comment?
Okay, so so let me just back up here, because there wasn't a question there, but let me respond to some of the things the assessors just put forth. A letter is not deemed to be received after 2 or 3 days. That's simply not true. Secondly, the notion that it would be onerous to hand deliver and prove receipt, that's exactly what's happening here. That is what a registered letter is. A registered letter requiring signature. The signature is the proof of receipt. Quite frankly, it's not semantics. It's open and shut. This was not received because it wasn't signed for. And then thirdly, just very quickly, you've mentioned going back to 2012. I have no idea what happened in 2012. What I can tell you is since 16, for I believe 18, 19, and 20, these requests were responded to. So it's not a question of an owner being derelict in their duty to respond. They have responded, but it appears that there's something, as I mentioned in the Lickerson case, where if there is any sort of question as to whether or not it was sent to the wrong address, if it was duly received, then there is no onus on the assessor to pursue non-compliance. That's administrative discretion. So in a situation like this, where we see that something clearly the connection was not made, it is inappropriate to pursue the non-compliance penalty. So I think that the biggest piece of evidence here actually comes by way of the assessor's submission, where we see that there was registered mail that was returned to sender and was not signed for by the receiving party. Therefore, a proper request cannot. It shows that it was not made. It was not duly received. So that's our position.
Okay. Um, Tracy or Gisela, do you have any other questions arising, or have you comfortable with the information we received so far to make our decision?
I'm fine, thank you.
Tracy?
Thank you.
Okay, thank you. And I am good too. I think we've heard both sides, and we're gonna recess now and go in camera and discuss what's being presented so far and make our decision when you return. Okay, thank you.
Thank you.
Mr. Chair.
Okay, thank you. I will call the hearing back to order. Mr. Story, Mr. Wong, the panel has considered evidence presented by both parties, and it is our decision that the request for non-cooperation will be allowed. So Mr. Story, the burden of proof will be on you. So you will start. And as you're the first presenter, could you please detail the roll number and everything and detail the property description and then make your presentation. Thank you. Mr. Story, you're on mute, yeah.
Sorry about that. Okay, Mr. Chair, we will be requesting that the assessment be confirmed then, but I will read the is it the roll number and civic address that you require, or file number, roll, and civic address for the record?
Yes, please.
Okay, thank you. So the file number is 21-296. The civic address is 415 Logan Avenue, and the roll number is 1308-178-5000. And we are then just requesting that the assessment be confirmed.
Okay, and Mr. Story, in your evidence, you never had a split. I mean, can you please confirm what value that you are requesting? Because there is a split in exempt.
No, yeah. we do have a split on the second page of our our evidence.
If you're asking,
so we're not disputing the exempt portion of 174,000. We are disputing the class code 40S, which is the multifamily portion of this asset, and we were requesting 1,389,900. Current assessment is 1,853,000 on the class code 40S, 174,000 on the exempt portion, class code 40E, giving rise to a total assessment of 2,027,000.
Okay, but you are asking that we confirm the city's current assessment at $2,027,000?
Well, yeah, if the penalty is applied, then we would ask that that be confirmed. Yes.
Okay. Would you mind reading those two figures, exempt and taxable?
Sure. Yeah. So the class code 40S is 1,853,000, and the class code 40E is 174,000.
Okay, thank you. Mr. Wong, any comments, questions?
No.
Okay, thank you. Gisela, any questions?
I have no questions, thank you.
Okay, Tracy?
I have no questions. Thank you, Mr. Chair.
Okay. So in summary, Mr. Story, you were asking for confirmation of the current assessed value.
We are, based on the imposition of the penalty, we're asking that the current assessment be.
Okay.
Thank you.
All right. So that concludes 415 Logan Avenue. Does anybody need a quick break? Or are we okay?
I'm good.
I'm fine.
Everybody okay? Okay. Okay, next property on the docket is 458 Balmoral Street.
Sorry, I guess for the previous property, so it'll be sort of the penalty is granted and then the value confirmed?
That is correct.
Okay.
So the next property on the docket is 458 Balmoral Street. We're dealing with a 2022 realty appeal We have a preliminary issue. Request for non-cooperation by the assessor. Mr. Wong, if you'd like to enter the property into the roll or into the, for the record, please, and then proceed with your request.
Sure. The subject property is 458 Balmoral Street. The roll number is 130-519-98200. And we're requesting that the burden of proof be placed on the applicant for non-cooperation as per section 53, subsection 3, and section 54 3.2 to be applicable as well.
Mr. Wong, would you mind explain what those sections are, rather than referring to the act?
Yeah, if you go to page 8. On page 8, the section 53.3 is the burden of proof for non-cooperation, where an applicant fails or refuses to, in this case, section B, to comply with the request for information and documentation under section 16. A board shall, at hearing of the application, place the burden of proof on the applicant on all matters at issue, and then the bottom of page 8 is the section 54 3.2, the effect of providing where a person failed to comply with the request for information or documentation under 16.1c, the board or panel shall specify in its order that any reduction in assessed value of the person's property is not to take effect until the year following the year in which the application relates.
Thank you. Okay, would you like to go through your history of the notice being sent out and that, please?
Sure. As per normal procedure, the city requested the information in April of 2018, but because there's no response to the initial letter, we sent out a certified letter in June of 2018, and we did not get a response, or we did not get a timely response from the property owner. So on page 10 is our certified letter as our proof of mail delivery. On page 11 is the letter requesting that the information be sent to us. You can see the underlined and bolded portion sent. It requests that it's sent to us by June 29th, 2018. And on the very last page, on page 17, we did receive a response, but it was dated July 11th, 2018. So in this particular case, they didn't respond by the deadline of June 29th, 2018, but they did respond. We did date stamp a response for July 11th, 2018. But we are requesting the penalty because they did not submit a response by the requested date of the first letter or for the second letter.
Maybe, excuse me through this story. So Mr. Wong, is there, have you included an income and expense statement that they did submit, although it was late?
Yes. just wanted to show that it's not that they didn't respond, but they didn't respond in a timely manner. And so, I mean, it could have been, in this case, it was July 11th, 2018, but it could have been, December 11th, 2018 or January 2019. But I just wanted to show that they did respond, but they responded late.
Okay. Mr. Story.
Yes, thank you very much. Okay, now let's establish some facts here. Mr. Wong, can we agree that this property has no history of non-compliance prior to this request?
They from 2008 to 2012, they did not respond. From 2013 to 2017.
Okay. Now, page 10 of your brief, again, we see the signature, correct? So that's how we know that it was delivered. And it was delivered to Manitoba Housing, correct?
It's delivered to the mailing address that is stated there, yes.
Care of Manitoba Housing, 7th floor, 252 Donald. Okay. And Manitoba Housing were managing this property at the time, is that correct?
I don't know.
Okay, well, it's in your evidence here. So on page 17, the income statement was provided in the standard manner that Manitoba Housing submits their forms. Is that correct?
Yes.
Okay, and in the top right corner of that same page, we see that it was received on July the 11th as part of Manitoba Housing's multi-role submission, correct?
Yes.
And Manitoba Housing was granted an extension for that year, as is typical when owners who require more time with large portfolios require more time to adequately satisfy this request. Is that correct?
Potentially.
Okay, so my question then is, why are we seeking the non-compliance penalty if this was submitted as part of Manitoba Housing's multi-role submission where they were granted an extension and where non-compliance was not sought on any of the other assets in that submission?
Well, I think you asked me to look into this, and I told you that in that particular year, they didn't, 458 Balmoral was not a part of the extension request.
Okay, do you have that anywhere in your submission?
No, but okay. You're asking me about it.
Well, I'm asking because the burden of proof is on you to show that they're non-compliant. If this was submitted as part of the Manitoba Housing multi-role submission, which it was, and they were granted an extension, which they were, then it seems it doesn't make any sense from.
If you can show that, you can show it as rebuttal.
Well, you would have that in your. That would be a request that was made to the city of Winnipeg, and typically Manitoba Housing gets an extension.
You're speaking typically, but you're not providing anything.
Well, it's okay. I can confirm with you that Manitoba Housing was provided an extension in this year. All of these submissions that I reviewed from Manitoba Housing have the same timestamp on them, July the 11th, 2018. This property was managed by Manitoba Housing, and it was submitted as part of
Was it a part of the request that they made?
I don't know.
Was 458 Balmoral part of the request that they made?
I do not have that communication between Manitoba Housing and the city. You, as an agent of the city, would have that communication.
Yeah.
Right? Okay.
Yeah, and I'm saying that 458 Balmoral was not a part of the request. That's what I'm saying. I'm not saying that for. No. That's just what it is.
Okay, Mr. Wong, I think we get both parties' point here, Mr. Story.
Those are my questions, Mr. Chair.
Thank you, Mr. Wong. Point taken. Okay.
My apologies.
No, nothing to apologize for. No. We understand both sides' submission now. Mr. Story, any other questions of the assessor? I think we're understanding what's going on. Thank you. Tracy, any questions of the assessor?
I have no questions. Thank you.
Gisela?
Yes, I just would like to go back for a second to understand, because I heard Mr. Story, you say, is this the first time that this owner did not respond to request for information?
I'm suggesting that they do not have a history of non-compliance. Their information is submitted as part of a multi-role submission. through Manitoba Housing. We don't typically see non-compliance from Manitoba Housing. So no, it's. I think the assessor is suggesting that in their request for an extension, the address on Balmoral, he's saying, was not included, but we don't see that evidence in his submission. So we know that this is part of the Manitoba Housing submission. It was sent to Manitoba Housing. It was submitted by Manitoba Housing. So clearly, this should not be non-compliant. The information was supplied at the same time as all of the other Manitoba Housing assets were supplied to the department.
And Mr. Wong, may I ask you, you indicated that there was no response from 2008 to 2010 and from 2013 to 17, is that correct?
If you take a look on my page 2,
Okay.
you can see the response history where from 2008 to 2012 we did not receive a response, but from 2013 to 2014 they responded. I believe it would be within the time within the requested time frame, and in 2015 to 2017 it appears they responded. They responded later.
They were granted an extension at that time. That's erroneous to say that they responded late. They did not respond late. They responded within the time frame agreed upon by the city.
If you let me finish, if they were granted an extension in 2015, they probably would have been on time. And but if they were not granted an extension in 2015, then they would have been late. But I don't know whether they were granted an extension in 15 and 16. But I'm fairly certain that they were not granted an extension in 2017, and so that's what happened.
Okay.
Thank you very much.
Thank you, Gisela. Okay, so Mr. Wong, in summary, looking on page 2, we do have a history of compliance, somewhat late from 2015, 2016, and 2017.
Like I said, potentially late. If they were granted an extension, it would have been on time. Yeah. But we don't know.
Mr. Story is saying that in his opinion, they were granted extensions, so they weren't late. Okay. But in this case, what the reason you're asking for non-cooperation is because they were basically 10 days late with their submission. Is that right? And Mr. Story, in his opinion, thinks that they were granted that extension. But the long and short of it is we're looking at 10 days or 11 days late in the receipt of the income and expense statement. Is that right?
Correct.
Okay. All right. Okay. Mr. Story, I think we've got a clear picture here. Is there anything else you'd like to present?
Just one quick thing, Mr. Chair. Just to confirm, it's not my opinion that they were granted an extension. I have confirmed with Manitoba Housing that they were indeed granted an extension, and all of their multifamily assets were submitted at the same time. This property was under management by Manitoba Housing. It was submitted as part of the multi-role submission. So it was not late, and they were granted an extension, and I have confirmed that with the client.
Okay, thank you for that clarification. I believe we've heard information from both parties. We're going to take a recess and go in camera and make our decision on this request. Okay? Thank you to both parties.
We're live, Mr. Chair.
Okay, thank you. I believe both parties are on mute. Okay, so I'll call the hearing back to order. The panel has considered presentations by both parties, and it is our opinion that the request for non-compliance, non-cooperation not be granted in this circumstance. So Mr. Wong, onus is on you, so you will begin, please. 458 Balmoral Street.
Yeah. Mr. Wong, you're still muted.
All right.
There we go.
The subject property is 458 Balmoral Street. The roll number is 130-519-98200. It's a residential apartment block that's 6 stories high. It was built in 1989, and it has 54 suites with 16 outdoor parking stalls. On page 3 is our income valuation summary. We use average rents of $842 to get a potential income of $545,000. We use 2.6% vacancy to get an effective gross income of $531,000. And we use 55% expense ratio to get a net operating income of $237,000. Capped at 5%, we have an estimated market value of $4,754,000, and which works out to approximately $88,000 per unit. The subject property, if you go to my page 4, our rent comparable showing that the rents that we've used are in line with what's on the market, and maybe even lower than a little bit lower than what the market is for these types of suites. In the middle of my page 4 are the market rents from CMHC. You can see that the listed rents for the particular zone, for the particular age category, and the number of units category. The weighted average for the subject property is $955 in terms of a market rent, and so like that's the $955 is higher than what we've applied to this property at $842. So feel that we've reflected this property as being a little bit below average in terms of compared to the market. The subject property is a nonprofit, and the income and expenses from a nonprofit they're not representative of market, and so I feel it's better to use market parameters in this case, because nonprofit rents are typically pretty low and their expenses are pretty high, and they don't represent a market value. So the model is using information from the market, and I feel it is representative of the market value. And the CMHC supports the rents that we've used, and it actually supports a rent that's slightly higher. But on the bottom of page 4, are just some expense comparables showing that the expenses the expense range in the comparables are 37 to 57%, and typically the newer buildings have an expense ratio that's a little bit lower, as maybe indicated by Hastings and Bison Drive at 37 and 42%. And in this case, we've applied a 55% expense ratio, which is probably a little bit on the higher end of the range in term for a building that was built in 1989. So we feel it is reasonable. Going on to page 5 is information on our cap rates and how they're derived. On page 6 are some cap rate sales. If you look near the middle of the page, that would be the multifamily section. In this particular case, the range in value per suite is about $70,000 to $174,000. I believe that this supports the model, which is coming in at about 88,000 per unit. And also the cap rates on page 6 support the cap rate that we've applied for the subject property. On page 7 is information on cap rates from Altus Group, indicating a cap rate of about 4.5% for the market, which I feel it supports the 5% that we've applied in this case. On page 9 is the location of the subject property along with a overhead picture. On page 14 and 15 is our CMHC information on CMHC market rents. And on page 17 and 18 is the income statement provided by the owner. So this is a nonprofit, and so using the actual information from the nonprofit, it's not representative of a market value. The model is driven by market information, and I believe that the rents that have been applied and the expenses that have been applied are supported by the market, and the cap rate is also supported by the market, combined with the fact that the value range is a little bit below market for a property that was built in 1989. I feel it's a fair and reasonable assessment, so I ask that you maintain the assessed value at $4,754,000.
Thank you, Mr. Wong. Mr. Story, any questions of the assessor's evidence presented?
Yes, just a few. Thank you. Okay, Mr. Wong, have you visited this property?
I have not.
Okay, to your knowledge, has anyone from the assessment department visited this property in the last, say, 10 years or so?
I'm not sure.
Okay, but you did mention that something about this property being slightly below market. Is that true?
Yes.
Okay, and so how did you determine that its income potential was below market if nobody's visited the property?
No, I'm saying that the property, it seems to be the model rents that we've applied are about $842, whereas like a weighted market rent is about $955. So it appears that the rents are a little bit below market, and the expenses are also, they seem to be a little bit on the higher end in terms of. And
okay, well, we'll get to the expenses soon, but are you aware of any deferred maintenance in this property?
No.
Okay, and so just to be clear, in the previous cycle, when it was appealed, you were not made aware of the condition of this property?
I don't know.
Okay, I'll get to that in my presentation. Now, the location of this property, this is in the Spence neighborhood, but it's bordering closely on the Central Park neighborhood. Is that correct?
Yeah, it's very close to the University of Winnipeg.
Right, it's very close. It's across the street is Central Park, and this is Spence. So do you think the location of this property would generally be considered a positive or negative from a market perspective?
Sorry, I was just looking at my overhead shot on my page 9, and it doesn't seem to be across the street from Central Park.
No, the Central Park area in Winnipeg, by the assessment department's map, if you cross Balmoral, you're in Central Park, and Manitoba Housing categorizes this as a Central Park asset.
Okay.
As evidence in their submission. Okay.
Yeah. Sorry, so what was the question again? Sorry.
My question is, do you think that that location, from a market perspective, would constitute a value positive or a value negative?
It's hard for me to say.
Okay. All right. So page 3, I'm looking at your income workup. Now, all of these inputs are modeled. Is that correct?
I believe so. Yes.
Okay. And the capitalization rate is modeled as well?
Yes.
And is that capitalization rate primarily based on the age of the asset, or what are the factors that go into determining a 5% cap rate on this property?
I believe it's the age and the size of the building.
Size of the building. Okay. All right. So there's no consideration for condition, for location, or for the fact that it is a subsidized seniors housing asset.
I'm not sure if in terms of the cap rate, no.
Okay. Now, we've talked about the income and expenses, and I agree. The income potential that's reported is based on rent geared to income, so that's not typically indicative of market. So we would look to CMHC as a baseline, which I think you've done here, which is fine. But I'm interested in the expense comparables that you've included on page 4. Now, how did you determine that these properties were comparable to our subject?
Just I guess I just wanted to. There was a little bit of a cross section in terms of, say, a newer building. This building is a 1989 building, and it's newer in terms of like the overall inventory of apartments, and I just want to give an overall range in terms of the expense ratios that might occur in an apartment building.
Okay, so just to be very clear, though, Bison Drive and Hastings would be vastly superior locations. Would you agree?
I would say it would be a superior location, yes.
Okay, and now we did request the civic addresses to review, but we were not provided. So I don't know the specific assets, but in terms of the expense ratios, are these stabilized, or are these single years, or?
They're single year.
They're single year, okay. And for Agnes and Sargent, as we get closer to what we'll call the core of Winnipeg, the expenses go up. Do those properties have parking lots, and do they have elevators?
I'm not sure.
Okay, and if they did, the expense ratio would typically be higher. Can we agree on that?
Potentially.
Okay. All right. So, and again, no adjustments were made to the cap rate or the expense ratio. This is all based on the model, and there's no consideration given to the site-specific attributes of this asset. Is that correct?
It appears that the rents are a little bit lower than market, and the expenses are a little bit higher than market. So I believe that there is some consideration there.
Okay, but just by the to the rents, the income potential, not the cap rate, not the expenses, just the cap rate, or sorry, just the rents, correct?
It appears.
Okay, page 5, your cap rate info. So the city suggests that cap rates, regardless of high rise, low rise, quality A or B, fall between 4% and 7.3%. With the 20th percentile falling at 4.9%. Now, that would put our property at the upper end of the quality spectrum by the city's model, would it not?
It seems to fall in between the 20th and 80th percentile.
Right, okay.
So it just seems like a very normal building.
Okay, and the broker's reports suggest that cap rates for good quality investment grade properties are between 5 and 6% for high rise or mid rise, I guess. But this would not be considered an investment grade property, would it?
I'm not sure.
Okay. And then for page 6 for your individual multifamily, these are not, none of these are truly comparable to our property in terms of location, quality, age, utility. Is that fair to say?
Say that again.
Well, the properties that you've got here, so we've got Roach, Talbot, Maxwell, and Ward. None of these are actually comparable to our property on Balmoral, are they? There's nothing downtown. They're typically.
They do seem to be somewhat similar in age, whether it be, like the subject property is a 1989 building, and so it is newer than some of these. But location-wise, it doesn't appear, no. Is Jared not there, or?
Appears to be frozen.
No, he's actually left. Yeah, maybe we'll just call a short recess until we can reach the applicant again, Mr. Chair.
Yeah, for technical reasons, we're going to take a quick recess to try and correct a Zoom feed there.
Okay.
Thank you. I'll now call the hearing back to order. Mr. Story, I think you were on about page 5, 6 in questioning the assessor.
Yes, thank you. And again, my apologies for that disruption. So we're looking at the cap rates, and I suppose, Mr. Assessor, my question is, based on these cap rates that you've submitted, is it fair to say that these are all vastly superior to our subject in terms of quality, in terms of utility, in terms of location and amenities?
I probably wouldn't agree with that.
You wouldn't agree with that? Okay, so which ones are that you've submitted here would be inferior to our subject?
Well, I mean, just purely on age alone, they're like the 1971, 1965, and 1960 versus the subject property's 1989. That would.
Okay.
They're notice. They're 89. They're 20, 25 years older. Right.
And have you visited any of these comparables that you're using?
No.
Okay. I think just go through the rest of your info here. I think that those are my questions. Thank you.
Thank you, Mr. Story. Okay, Tracy, any questions of the assessor?
I do not have any questions. Thank you so much.
Thank you. Gisela?
I have no questions, Mr. Chair. Thank you.
Okay, thank you. And Mr. Wong, 2 quick ones. So the subject is located on Balmoral west side facing the research lab, National Research Lab. Would that be accurate?
Yes.
Okay, and it's a subsidized nonprofit complex.
Yes.
Okay. That is my only question. Thank you. Mr. Story, when you're ready, please.
Okay, thank you very much, Mr. Chair. So again, our subject is 458 Balmoral. We're located on the west side of Balmoral in the Spence neighborhood. And as I had pointed out, we are in close proximity to the border of the Central Park neighborhood. The improvement is a 6-story structure built in 1989 as a nonprofit seniors housing facility called the Saigon Center. It has 54 units, where 5 units are currently unfit for occupancy due to water damage. I toured this property, I'm going to say 1 to 2 months ago. I did a full inspection with the owner, and I've got some photos, and we'll get to at the back end of my brief. But there are some units that are completely unfit for occupancy at this time. The property has a considerable amount of uncured deferred maintenance due to a prolonged lack of upkeep. We observed water damage throughout the building. We have a condition report from 2016 recommending that the total capital costs in 2016 are approximately $3 million. So I'd like to point out there is at least $3 million worth of capital costs that have been suggested to remediate this building to bring it back to a standard that is appropriate. None of that work has been done, save for some lighting upgrades in the common areas, and there were some cameras put outside, but they were stolen after they were put up. The property has considerable safety concerns. Upon the inspection, it was noted that break-ins and trespassing are normal. Criminal activity requiring police intervention occurs frequently. And we also note that the owner's suite was robbed 2 days prior to the inspection. So, and during the inspection, we did encounter a trespasser in the mechanical room on the 6th floor. So there are considerable safety concerns, and there are considerable deferred maintenance concerns in this property. There are 35 outdoor parking stalls, only accessible by a laneway off of Spence Street. And the size site, according to the city of Winnipeg, is 23,151 square feet. No, my brief is not. So effectively, the assessor has pointed out rightly that because we have a rent geared to income, not-for-profit, subsidized seniors housing asset here, we do not rely on the actual rents because they're depressed. So we look to CMHC. In this scenario, we have accepted the modeled parameters for the income. So, sorry, I'm just frozen here, but I'm going to be moving along now. Okay. So in terms of the expenses, we have used the actual expenses stabilized over 3 years into a typical, what we'll call a typical year, as is consistent with market behavior. And you will note that we come to an expense ratio of 67.8% based on our findings. Now you'll see on, if you allow me to jump around a bit here, page 9 of my brief shows you the 3 years stabilized expenses. Again, the income is accepted, but the expenses are actual. There's the assessor had mentioned that the expenses are higher in not-for-profits, but that's not a function of not-for-profit, so to speak, but rather a function of the actual physical assets. So we're looking at insurance, professional fees, and utilities and things of that nature. So you see on line 33 that there is a negative net operating income that's effectively about $300,000 in the red per year. So this property is losing money based on what we see here, and the operating or the expense ratio.
Jarrett, you frozen again.
Kara, maybe we should proceed via telephone with Mr. Story. Maybe that should be suggested.
Yeah, you know what? I had sent that to him in email in the first time this occurred.
Shall we recess for a short period until we can reconnect with him? Oh, there he is. Okay.
And we'll just need him to unmute.
I'm sorry, folks. I don't know what is happening with my computer here today. Okay, so we were talking about expenses. Our expense ratio based on actuals is 67.8%. Now, the major issue that we have here is the cap rate. We believe that the assessor's cap rate of 5% is far too low. We do note that the assessor does show that cap rates within the city fall by their metric between 4 and 7.3%. So we are suggesting that an upward adjustment to 7% to capture some of the site-specific issues with this property, including the deferred maintenance, and some of the issues that are apparent based on the location, based on what's been reported by the owner. So from a site-specific view of this property, the market would likely adjust that cap rate higher than the 5%. So we are using 7%. This is supported by the literature from the Appraisal Institute that suggests that in order to, this is from Robert Polton's book, for affordable housing, typically the appropriate way to develop a market cap rate for non-market assets is to find a cap rate that is typical of market and then adjust upward for the for some of the derived or for some of the risk that affects the real estate asset. The municipal board order that I've included here, A02330, quotes from the appraisal journal that states that low investment grade apartments warrant a higher yield and overall rate than conventional apartment properties. The applicable rates tend to rise with the presence of each of the four characteristics attributable to these properties: low cost or low quality construction, advanced staged, declining or blighted neighborhood, and low income tenancy. So our justification is that we would typically apply a cap rate of 5.25. But again, given the specific assets facing this, specific issues facing this asset, we have adjusted it to 7%, leading us to an indicated market value at the reference date of $2,448,000. I've included some site inspection photos. We talked about the condition. If you'll come with me to page 12 of my brief, this is the mechanical room where people have been trespassing for the last number of years. You'll see that there's graffiti and general detritus, and they've broken locks off the door to the roof. So that's a considerable issue. In page 13 of my brief, we can see that there's water damage throughout the building. There's a leak on the 6th floor roof that has not been remediated, and it's causing all sorts of problems throughout the building. So there's photos of the water damage there. One of the suites that's been rendered inoccupable is on 16. You can see that they've had to tear it down to the studs to rebuild it based on some of the water damage. Just take your time with those and please peruse those at your leisure. Page 18 is a typical occupied suite. This is a 2-bedroom. One of the fellows who walked me through was kind enough to show me into his suite so we could get a general sense of what an occupied suite looks like. So you can see that the finishings would best be described as low quality or utilitarian, utility grade. Page 20, let's see, I believe it's 23. Yes, 23 shows an occupied bachelor suite. This is the owner's suite where he experienced a break-in because he is at grade. So his back door actually faces onto the parking lot. And again, substantial safety concerns. You can see the quality of the finishing there is low quality, to be certain. An unoccupied suite that has been prepped for occupants is on page 24. You can see the flooring remains the same in the main areas. They put some hardwood. Those are it's laminate flooring, and they've done some painting. But you can get a sense of what this property looks like in the interior suites. Now, I had mentioned the deferred maintenance. I've included a report. I should say too, there is a common area on page 30 of my brief. This is typical of seniors centers. This is a main room, a main sitting room, where the folks play ping pong and socialize. So that is included. And then the office is on page 30, where the owner manages the asset. Now on page 32, I have an observation report dated 2016. I'd like to go through it with you. There have been concerns about this building and the lack of basic maintenance and upkeep that go back to 2016 and 2013. The site visit in 16 concurs with previous observation that the building shows a prolonged lack of basic maintenance and upkeep. it's very clear that there's not been in place a capacity to manage the building. The effects resulting from the long-term circumstances are that many components are now in need of replacement or repair, and many components have prematurely reached the end of their life cycle. Significant capital upgrades are recommended for the building to be a sustainable asset and continue as a viable rental property. So again, this speaks to the cap rate issue that we're requesting. We'll go on here on page 33. The comments say that at the time there were 21 vacant units. The 54 interiors range from at best poor to many vacant units being uninhabitable. Inattention and ineffective repair attempts to water leaks in bathrooms, kitchens, windows have resulted in rotten wood, drywall, and varying degrees of mold. Windows and doors are covered in tape, and this is consistent with what we saw on our most recent inspection. The rooftop air makeup system is designed to provide ventilation to the hallways and under the entry doors to each suite. The separate exhaust system is to draw out through grills in each bathroom and kitchen. However, both the air makeup system and exhaust system were not functioning. So heating is provided by electric baseboards. Many are in poor condition and damaged. It is a flat, built-up tar and gravel roof, and there was an active leak that has not been remediated, and that gives way to some of this water damage that we're discussing. So effectively, we are accepting the potential net market income because we have a rent geared to income asset. We typically do check the assessor's rents to ensure that they're in line with CMHC, and in this case they are, but we have used the actual expenses and stabilized them over 3 years. So that is a point of contention, and the major issue that we have here is that the cap rate of 5%, given the site-specific attributes of this property, are far too low. There's substantial remediation that needs to be done. So we have adjusted that cap rate to 7%, which we recognize is very high, but this is there are some very, very may I say dire site-specific issues here that need to be addressed. So with all that being said, we are requesting that the value for the 2022 tax year be amended to $2,448,000. And barring any questions, that's my presentation. Thank you.
Thank you, Mr. Story. Mr. Wong, any questions of the appellant's evidence? And maybe I'll state right now, I understand that you've made a rebuttal evidence regarding Mr. Story's presentation. Is that right?
Yeah, just a little bit of information regarding cap rate.
Okay, but maybe we'll deal with the questions first, please.
Yeah, okay. So your requested value is $2,447,000 or $48,000?
$2,448,000. That's correct.
Okay, and that works out to about $45,000 per unit for like 11 one-bedroom units, 20 two-bedroom units, and 20 three-bedroom units. Have you ever seen any apartment building that with that type of a suite mix sell for $45,000 a unit?
I think I've made it quite clear that we're considering the condition of this property. Now,
have you
yes, of
seen
course. Hold on.
property in this condition sell for this rate?
Have I seen a property in this condition sell for this rate? I don't know that I've seen a property in this condition that requires north of $3 million worth of work where the assessed value is that's almost half the assessed value. So I agree, $45,000 per suite is extremely low, to be certain. Now, all these suites are not occupiable, and this asset requires a huge amount of work. So
okay, so
hold on, Mr. Wong, please let me finish.
Well, I asked you if it was low, and you answered it.
Well, I'm trying to answer your question. It's not this is not a question of looking at suites that are in habitable condition and then saying, well, isn't 45,000 low? Well, it's a metric of a per suite basis is not appropriate here because this asset requires substantial renovation, substantial work to bring it to a standard of habitability. So
And in your cap rate study, one of the properties is 512 Balmoral.
That's correct. Yeah.
And once again, that property is like a price per unit is 62,000. That's comprised of, I guess, mostly one bedrooms, and it's sold for 62,000 per unit.
Right. So that would likely support what I'm saying. This is a property that was occupiable. It's not built for social housing. Yeah, I'm failing to see your point there. That's it's not comparable in terms of it's not a social housing asset. And again, in order to derive a cap rate, a market cap for properties that are affordable housing, the typical or the accepted methodology that we would use, supported by the evidence that I've provided today, is to look to the market, to use a baseline market cap and then adjust upward for specific attributes. Now, there's nobody in the market who would look at this property and say, well, that would not consider the substantial amount of work that would have to go into it. That's goes without saying. So it is very specific. It's hard to use any property from our cap rate to say that it's directly comparable. It's comparable with adjustments, and certainly the one in Balmoral at $65,000 a unit might be typical of this property once it was remediated.
Okay. So you feel the 45,000 is a fair value? Is a fair value?
I think that an adjusted cap rate to the higher end of the range is absolutely appropriate, given the site-specific issues that we have that I think I've outlined quite clearly here. I think that that's appropriate. Yes, I think that a lower cap rate would not be indicative of a market view of this property. So yes, I think that using the metric of on a per suite basis, if we have 12 suites that are not occupiable, then we get to about 60,000 per suite, right? Roughly. So it's not using the metric of cost per suite pre-renovation doesn't make a lot of sense to me. But using a 7% cap rate or a cap rate that skews to the higher end, given the condition, given the fact, and I will reiterate, this property in 2016 there's a condition report that suggests $3 million need to be done. So
no, and asked and answered. Thank you. Mr. Wong, any other questions?
No other questions.
Okay, thank you. Mr. Wong, okay. Tracy, any questions of the appellant?
I have no questions.
Isabella.
I just have a few questions to clarify. I'm assuming that all of the suites are occupied aside from the 5 that cannot be occupied due to water damage? Is that correct?
No, there are 5 that cannot be occupied due to water damage, and then there are 7 that are currently unoccupied today. So 12 in total are unoccupied. Yeah.
Okay. You indicated that the owner's suite was broken into a few days before you did your review. I thought that this was owned by the Vietnamese Nonprofit Housing Corporation.
It is. This is, sorry, I should say the president, the fellow who runs the organization. That is his suite. He took me around with another fellow who lives there. That's his office that you see in the photo next to the common room. But he's the president, I suppose, as opposed to the owner, but the president of the Vietnamese Not-for-Profit Association.
So I'm also assuming that this building is subject to rent controls?
Well, no, it's RGI. So rent control would typically be a private apartment. So this is rent geared to income. So this is these are subsidized rents. These are rents that are it's typically based on 30% of the occupant's income, with the shortfall being made up by Manitoba Housing by way of transfer.
And the report that you indicated in terms of the capital costs required to remediate what's going on here were dated 2016.
That's correct.
I'm wondering, has that grown because of more water damage, these 5 suites being unoccupiable and having to be repaired?
Yeah, that's a great point. So they did condition reports throughout, I believe, let me pull it up here. I believe they said the first one that they did was, I think it was 2003, but I don't want to misspeak. So let me just have a look.
Mr. Story, the question is the current condition, sorry, Gisela, is the current condition indicative of the 2016 report?
Absolutely. So there were reports in 2006, 2013, and 2016, and they are absolutely indicative of the current condition. Okay. If we search the permits on this property, we can see that the only work that's been done is for some lighting in the hallways. Okay,
thank you. Go ahead, Gisela.
And my only other question is there a plan for maintenance and remediation?
Not that I'm aware of.
Thank you. That's all my questions.
Okay, thank you, Gisela. I do not have any questions. Mr. Wong, you have some kind of rebuttal?
Yeah, actually, yes. Do you guys have it or?
Yes.
Oh, okay.
I do not have it. I'd like to review it if possible.
I just now emailed it to you, Jared. You should arrive in your inbox any moment.
Okay, we'll let Mr. Story get a copy of that, and then Mr. Wong, you can proceed once he's confirmed that, okay?
Yeah.
Thank you.
Yes, I have it now. Thank you.
Mr. Wong?
Yeah. It's just some rebuttal evidence in terms of the cap rate that the applicant has provided for 100 Southview Crescent.
What page would we be referring to in the appellant's brief?
The cap rate study on page 4.
Okay.
So on the property on the far right is 100 Southview. And they're indicating a cap rate of 5.59%.
Okay.
And I just wanted to, and on my document, okay, so I guess on my rebuttal document.
Yes.
So just indicating, I just wanted to show that the cap rate that Altus has calculated is 5.59%, and the cap rate that the pro forma indicated in their cap rate study is 5.82%. But the cap rates are based off of estimates, so they're not based off of any actual information. They're just they're estimated repair and maintenance. But when you put their actual information, in this case, their 2017 income statement against their sale price of $38 million, the cap rate is 5.05%. And I just wanted to show that the Altus cap rate is a very estimated cap rate, whereas like when you look at their actual information, their cap rate is closer to 5%.
Okay. Mr. Story, any response?
Sure. Yeah. Okay. So I'm very familiar with 100 Southview. Now, I guess, first off, 100 Southview is townhouses. They're new. They rent at a premium. They would bear no relation to the property that we're dealing with today in any stretch of the imagination. But just for the sake of argument here, the fair tax appeal I was with Fairtax at that time. I can tell you that the EGI is likely based on the fact that they were not at full occupancy. That asset was being built. That's a newer property. I believe that it was finished in 16. And I also know that the owner purchased that asset at a cap rate north of 5%. We were acting as the agent's owner at that time. So I guess in the interest of narrowing our issues, I will say that this property has literally no bearing on a social subsidized housing with substantial deferred maintenance downtown. So I don't have any questions of the assessor related to Southview.
Okay. Mr. Wong, anything else?
No.
Okay, thank you. Tracy, do you have any questions of the appellant?
I do not. Thank you, sir.
And Gisela, we already did that, right? Okay, I'm sorry. Okay. Any requirement for summary by either part, Mr. Wong? I'll let you go first.
Sure. I just want to say, like, the average value of apartments is probably over 100,000 per unit, especially if you consider that if they're like a lot of 2 and 3 bedroom units. We've valued the property at 88,000 per unit, so we've valued this property at the lower end of the range for a 1989 building. I mean, granted, it is maybe the location isn't the best location, but it's I think we've reflected that in a slightly lower than average value, and the information that that I've provided is supported by the market. So I ask that you maintain the assessed value at $4,754,000.
Okay. Thank you, Mr. Wong. Mr. Story?
Yeah, it's just in summation very quickly. I think we've made our point here that this property, from a site-specific view, from a market view, would be seen as having substantial issues. It would not simply be reflected in the potential income. It would also be reflected in the cap rate. The cap rate, of course, as we all know, is the numerical expression of risk. And when we look at the potential for the durability of the income for this asset, for the potential for the income to grow, that is virtually impossible unless a huge amount of work is done to this property. So we are looking to a site-specific valuation of this asset, and given everything that we've observed in our inspections, what we've seen by the reports telling us about the condition, we believe that a cap rate of 7% is fully supported. Again, given the site-specific issues facing this property, and so we believe that our value of $2,448,000 is supported, and we do respectfully submit that the value should be adjusted to $2,448,000.